they had actually told my clients, same bank, two different branches, two different people, oh, don't do what the attorney told you to do. Do this instead. Hi, Jeff Marsacci, the Plain English Attorney, and welcome to the video. Today we are going to talk about a question that came up on Reddit's r/estate planning, and it's about a revocable living trust, and it looks like the bank might have screwed things up. But don't worry, it can be corrected. So let's go ahead and check out the poster's original question. Questions on a revocable living trust. My mom met a man 30 years ago. He was a married man, but he and his wife had already separated for 10 years when they met. He's now 92. They had never filed for divorce. He recently set up a trust and named my mom as the primary trustee. So my questions are, will his wife still be able to contest with my mom for his real estate after he passes? Or does my mom being the primary trustee override that? We made an appointment with his bank a couple of months ago to put his bank account into the trust, but the person who specializes in that area was out sick that day, and someone else without any living trust knowledge helped us and only put my mom's name down as the beneficiary. So is naming my mom as the beneficiary to his account the same as putting the account in the trust? From my own personal understanding, if he just names her as a beneficiary, his wife is still eligible for 50% of his account balance. But if he puts the account into the trust, then my mom gets the whole 100%. Am I correct on this? If so, then we may need to make another appointment with the bank. Okay. Yes, the bank messed up here. So the situation, and it happens way more than you would think, particularly with someone who's 92, the not getting divorced, but just going your separate ways, it was a lot more common. You know, you start going back 20, even 25 years ago, that was not a common occurrence anymore. But prior to that, yeah, it just sort of happened. But the problem is there are a lot of legal loopholes and different rights and other things that can just pop up because, I just don't want to go through the bother of a divorce. Well, that does mess things up. So let's go ahead and start to take a look at what some of the other people in the community are saying and what their advice is. As always, only a lawyer can say for sure after careful review of the trust statement and the facts of the case. Primary trustee. Do you mean that there is another co-trustee? Is the man dead yet? If not, then typically the revocable trust is his alone. He is both the current trustee and the current beneficiary. And yes, that is exactly how the revocable living trust is designed to work. You're setting up this trust on your own. You're the trustor, you're the trustee, you're the beneficiary. And then you have your successor trustees and the beneficiaries who take after you've passed on. But up until that point, it's all you. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Continuing with that, will his wife still be able to contest? Just about anybody can contest just about anything. Your mom being trustee shouldn't have any relationship to who is the beneficiary. Plus, the wife has a legal standing that improves her chance of actually winning the contest. So that's exactly what he probably didn't want to hear. That, yeah, it's his wife. They can get to that account. But that distinction was actually pretty important between who is running the trust doesn't mean they're the beneficiary. And I sometimes come across this, particularly people who haven't looked through videos, done a lot of research. They just assume that the person they're going to name as the trustee has to be the beneficiary. They have to get it. And, well, wait, I don't want them to get it, but who's going to be in charge? And I want it to go to my kid, but they're not responsible. Whoa. Trustee is just who's running the ship. They're not the person who's the passenger. They're not the beneficiary who's going to receive the funds. The trustee is the person who manages things. Is it common for a spouse, or in this case, just an unmarried partner, to be in charge and also be the beneficiary? Yeah. However, when you're doing this in the confines of a revocable trust, it's for the assets in the trust. This is pay on death, which, because it's not already in the trust, makes it a little more vulnerable to going into probate. So let's go ahead and continue on and see what else we've got for the advice. And this is from the poster. Yeah, I'm the second trustee after my mom. And yes, he is still living. My mom and I actually quit our jobs in September because he needed someone here with him and asked us to move in with him. Another person, but who's the beneficiary? Trustee does not mean beneficiary. Absolutely. My mom, then I. Okay, now we've got some clarity on that. So the mom is the beneficiary. And here's some more advice. That's a doozy. And at age 92, I'm imagining he's not chomping at the bit to get that divorce done. I imagine he talked about it explicitly with his estate planning attorney, and if not, he certainly needs to. His wife can always contest anything, even if the trust planning is all ironclad. Whether she succeeds or not is another story, and that's with an exclamation point. And that's very, very true. It doesn't matter that your mom is trustee. What does matter is the language of the trust and how the rest of the estate plan was structured. This actually brings me back to day one of law school. This was just laid right out. Look, anyone can sue anyone for anything at any time. The question is, will they win? And that's what the next 3 years are going to be about. And it was very true. Anybody can bring a suit. It's just, are they going to be successful? And us going through all of that as law students and figuring out, would they win? What are the concepts? What are the principles? Was very, very important. So can she sue? Yeah. But how you have things set up can matter greatly. Depending on the state this is happening in, his wife could probably make an argument that she is entitled to a, quote, spousal elective share, which is the legal right surviving spouses have to a deceased spouse's estate. In my state, Connecticut, the way to avoid that would be to have the estate passed to a non-spouse beneficiary through the trust, which is outside the probate estate, and thus not subject to the elective share rule. Even then, there are some assets like employer retirement accounts that have their own rules regarding spousal inheritance, so the estate planning attorney probably took care to consider how each asset should be treated here. He should listen to what his estate planning attorney says when it comes to account ownership or beneficiary designations, not the bank. If the attorney says to have the account transferred to the trust, then by gum, he better transfer it to the trust. Time to make another appointment with the bank. Very true. The bank here, they really could have screwed something up if they didn't just lay out, okay, we can do this, we can do this, we can do this. Here's what the different ramifications are for each of them. But what they should have done is, well, the attorney said to put it into the trust. They should have just put it into the damn trust. They shouldn't have just gone off and done whatever else they would have wanted to do. And unfortunately, I end up seeing this sometimes with bank personnel. The easiest thing for them to do in terms of paperwork is a pay-on-death beneficiary designation. Changing ownership, the forms are typically 3 to 4 times as long, and it may involve even more, especially with bank accounts going into a revocable trust. They may very well have to close one account, open a new account in the name of the trust, and if it's I got enough to do. Let's just change the beneficiary. Then suddenly you're in for a world of trouble. So let's continue and see what else we got. It's hard for him to communicate with the attorney. He's hard of hearing, and his ability to understand questions is shot. His memory is also very questionable. He asked me to do all the talking, so I will try my best to find out. Well, it's kind of sounds like there may be some competency questions, which means it's even more important to talk with the attorney. Another comment, if the assets are held separately, then he should have the unilateral right to transfer those to his own trust, even if still legally married. Having your mom on as beneficiary isn't a problem, but that means the trust will not control that asset. And the comment under that, everything needs to be titled in the name of the trust. Beneficiary is not the same and will potentially cause problems. All right, let's jump back to one of the parts that they had in that question. If it's not in the trust, does the spouse get 50%? Well, that's probably what we're talking about with that elective share. Whatever state they're in may say that the spouse is entitled at a minimum to 50% of the assets. Okay. This is one thing I sometimes hear the children, well, how dare they cut me out, or I should have gotten more, I'm entitled to more. No. The fact is, nobody is entitled to anything except the spouse. The only rules that I've seen, and if there are any attorneys out there can correct me if I'm wrong, only a spouse is entitled to part of an estate. If you do a plan that cuts everybody else out, that's it. Tough luck. So that 50% reference is probably in that state. An elective share is 50% for a spouse. So that could cause some more trouble. Let's keep going. And now we get to where I put in my 2 cents. So many things can go wrong in this situation that it is best to talk with an experienced estate planning attorney. And it sounds like you have one, but just not have spoken with them about these items yet. Here are the things that stick out immediately to me. Go back to the bank and demand that they do what you originally asked them to do, which is title the bank account in the name of the trust. Naming your mother as the beneficiary is not the same as changing ownership. What if your mom becomes incapacitated? The wife goes to court and becomes a guardian and starts making changes to the account at the bank to make herself the beneficiary. You might be able to fight it, but now you are going to court to fight that. What if your mom passes on before he does? The account goes to probate and the wife makes an elective share claim, as another commenter suggested. All of the different contingencies can be handled in the trust, but not on a bank's beneficiary designation form. And that's a critical piece to it. What about all these different contingencies? Here's what when you're talking about beneficiary designations or making someone a joint owner on an account with a right of survivorship, I kind of call it duct tape planning. It's only good for one shot. Okay, if the motor's falling out of your car and you're going to use duct tape on it, it's only to get it to the repair shop so you can really fix things up. The one kind of big exception is the only real way to preserve some favorable tax consequences is naming beneficiaries directly on retirement accounts, or take the added step of having it go to a specific IRA trust. But that's not what we're talking about here. We're talking about a bank account. So what else do we have going on here? As an aside, if you specifically ask to have the account transferred into the name of the bank and the bank recommended instead naming your mother as the beneficiary, in the state I'm licensed in, North Carolina, that could be considered the unauthorized practice of law. Banks are allowed to discuss different options such as joint ownership, beneficiary designations, etc., and what those terms mean, but suggesting a course of action is considered legal estate planning, and a complaint could be filed with the state bar for the unauthorized practice of law. What may have happened is there is a lot more bank paperwork involved in changing ownership of an account, including probably opening a new account in the name of the trust and moving the funds. And the staff member at the bank decided to take an easier route of naming your mother as the pay-on-death beneficiary, or the staff member just didn't know what they were doing. But a beneficiary designation and moving ownership to a trust is not the same thing. And unfortunately, this becomes an issue. It was a big issue 3 to 5 years ago, and it was one bank in my area in particular that was doing this all the time. And thankfully, that bank is no longer around in the same form, and they kind of merged with another bank that had much higher standards in this particular area. They had actually told my clients, same bank, 2 different branches, 2 different people, oh, don't do what the attorney told you to do this instead. The attorney doesn't know what they're doing. In both cases, this was people moving hundreds of thousands of dollars into an irrevocable trust, start the 5-year clock for Medicaid, and what the bank was telling them to do would have put all those assets on the table for Medicaid to say, no, you have to spend it down. So I don't play around with that anymore. I even put into my engagement agreements that if a bank is practicing law in this way, telling you don't do what the attorney said, they're okay with me with attorney-client privilege. They're waiving the privilege for me to go ahead and report that bank to the state bar for the unauthorized practice of law. It's serious enough that when they're messing around like that, they're not lawyers. They can only tell them what these accounts do or not do, but they cannot suggest a course of action. That's giving legal advice in the end. Next, while he probably won't want to go through the process of a divorce at 92, it is worth a discussion with the attorney so they can lay out the pros and cons and he can make a decision based on the attorney's advice. I've heard it all before, but we haven't spoken in decades. Oh, he or she would never do that by claiming an elective share. We're basically been divorced without the paperwork, so it shouldn't matter. Look, if you are married to someone, that comes with a host of rights, privileges, and responsibilities, and people do funny things when there is a death and money on the table. As an aside, if the wife ends up needing Medicaid to pay for nursing home care, his assets are on the chopping block for a Medicaid spend down. And there's no telling what kinds of legal actions the wife's family might do to get her the care she needs, including trying to make him pay for her care. So this isn't just an inheritance issue. This could also, being married, be a more complicated Medicaid type of issue. And let's continue and keep going. Finally, a divorce light option might maybe to have the wife waive her rights to be considered a fiduciary for him or a beneficiary of his estate, including specifically waiving the right to an elective share of the estate, and he, of course, should be willing to do the same. Discuss this with the attorney. In the state I'm licensed in, if this is done in the form of a separation agreement, typically done to settle property issues prior to divorce, it takes 1 year of living separate apart in North Carolina to get legally divorced, and one of the parties dies before the divorce is final, then the separation agreement is often enough to bar the elective share from being exercised. So this is an important thing, that in the context of divorce, if you've got that in writing, yeah, we're cutting off the elective share, even though we haven't lived separate and apart, the spouse doesn't get to come back and say, well, we were never really divorced. Not yet anyway. I want my elective share. No. They've already kind of settled those property rights. These are all issues to discuss with the attorney, but if you can get to the bank to change the ownership of the account so it is owned by the trust before you get an appointment with the attorney, then I would suggest getting the account into the trust ASAP, as the attorney probably recommended this in the first place. So yeah, this is one of those things where the duct tape solution of beneficiary designations could get in the way of a whole host of problems, including ending up taking part of that inheritance, or as the person who was posting it suggested half in their jurisdiction through that spousal elective share, well, then get it into the trust. So, banks are typically only looking at what has to happen around their context of working with the accounts and working within their bank's specific internal regulations and procedures and forms. They can move that account into the trust, or at least set up a new one in the name of the trust and move the funds. That's what they should have done. Okay, so hope you learned some really good stuff about this. Please, if you'd like this video, go ahead and click the like button and help us out by subscribing to the channel. The more subscribers we get, the more likes we get. Those metrics get that information out there, and I think this information is valuable for people to see, and I hope you think so too. So as I always tell my clients, please stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.